Most people who are arrested and charged with crimes in Central Florida have never been in trouble before. That means that they've never gone through the system and have no idea how it works other than what they've seen on TV. Because of this lack of knowledge and experience, the entire process can be frustrating, confusing, and terrifying if they don't have the right legal allies and support in place. Having the right criminal defense attorney doesn't just mean that your case will be handled competently, it also means that you have someone who can educate you about the process, tell you what to expect, and help you take the right actions to ensure that the situation has the least impact on your life, your reputation, and your future as possible. In this video, I'm going to give you a 30,000-foot look at a typical criminal case and how that case moves through the court system. A criminal case will start with either a physical arrest or a notice to appear issued by a law enforcement officer. If a person's arrested, they'll be transported to the county jail in which they were arrested. There, they'll have to be processed through the jail and then will either have a bond automatically assigned to them or will have a first appearance hearing in front of a judge at the jail. At that first appearance hearing, the judge will inform the individual of what they were arrested for. The judge will then set a bond if the person's eligible for one, and the judge will either appoint the public defender's office to represent the person or inform the accused that they have a right to hire a private attorney. Even if you're assigned a public defender, you still have the right to hire a private attorney. You do not have to use the attorney that the government assigns to your case. For most people, the time spent at the jail will be the worst part of their entire ordeal. Once they get bonded out and hire a good criminal defense attorney, most of the weight and the stress of the situation should be lifted off of them. The attorney should then take care of everything related to the case moving forward. After the accused bonds out of jail, they'll get a court date called an arraignment date. The arraignment date is usually held at the downtown courthouse for that particular county. An arraignment hearing is a formal court hearing where the charges filed against the defendant by the prosecutor are read aloud and the defendant is required to enter a formal response. This response will be a plea of either guilty, not guilty, or no contest. It's in the best interest of 99% of individuals to enter a plea of not guilty at this juncture because they have not had any opportunity to review the evidence against them and work out a good resolution to their case. By entering a plea of not guilty, it also allows the individual more time to hire a private defense attorney who can review the evidence against them and get the accused a better result or outcome than what they would have faced alone at the arraignment. If you hire an attorney prior to your arraignment, then you actually don't have to attend that arraignment at all. Your attorney will waive your appearance, enter a plea of not guilty on your behalf, and demand discovery from the state. It's in most people's best interest to hire a private attorney prior to their arraignment date. The faster you hire an attorney, the more time they have to get out in front of the prosecution and begin dictating the case instead of starting halfway through the game and needing to respond to the state's actions against you. Arraignments are usually not specific to the defendant, which means that there can be hundreds of people who all have their arraignment on the same day at the same time in the same courtroom. We actually call the arraignment a cattle call because there are hundreds of people there for their arraignment and they're called up one after the other. If your last name starts with P, like mine, you'll probably be waiting there for hours for your case to be called. By hiring a private attorney, you wouldn't have to go to your arraignment date at all. The next court date is called either a pretrial conference or a docket sounding, depending on what county you're in. Between your arraignment and your first pretrial conference or docket sounding, a lot will happen. Your attorney will start to receive discovery from the state, that is, all of the evidence that the state has against you, and will also file reciprocal discovery. That is, all of the evidence that you're able to give to your attorney, such as pictures or text messages or something like that, depending on the charge. It could even be physical evidence like a torn shirt showing that you were attacked and acted in self-defense. Your lawyer will also start identifying witnesses that may need to be deposed or work on getting affidavits from those witnesses. Your lawyer should also begin working on and filing an exhibit list of the things to be used as evidence in your case. Sometime around that first pretrial conference or docket sounding, you'll also get an offer to resolve your case. This offer can either be a very reasonable offer or it can be a harsh and unreasonable offer. Your attorney should be able to tell you what they think is reasonable and what isn't based on your charge, the facts of your case, your criminal history, and the county that your charge is in. Depending on where the prosecutor is at with their offer at this stage, your lawyer may choose to continue the case to the next docket's pretrial conference or docket sounding and get more time to file certain motions to attack the state's case, such as a motion to suppress, a motion to dismiss, a motion in limine, or various other pretrial motions. These motions will then be set for evidentiary hearings. Based on the outcome of these hearings, the state's case can either be dismissed by the judge, dismissed by the state, or the state's case can be weakened for trial, and you may get a better offer. The state could also win these hearings, in which case they'll feel more confident about winning a trial and will likely stick to a harsh offer that they've already provided. So it's very important that your lawyer understands all the nuances about how prosecutors think and how the system really works before they just start filing motions just to file them. Your attorney should also know the relative strength of the case after reviewing and analyzing all the discovery, as well as conducting depositions of the witnesses to see what their testimony will be. Criminal defense is chess, not checkers, and everything that's done to defend a case must be done purposefully and strategically while weighing the pros and cons of each action. Most cases take about 6 to 12 months to resolve. Sometimes they can be much faster or take even longer. It all depends on a number of different factors. The fastest result is not always the best result. Some people need their case to end by a certain time due to life circumstances, while others even prefer that their case get dragged out. Each person's case and life situation are different, so we're sure to discuss all of this with you to understand your biggest concerns. Once all of the pretrial work is done and completed, the state will usually offer their final offer to resolve the case prior to trial. The decision to accept this offer should always be balanced with the risk that the defendant faces at trial. For example, if you have a charge for possession of cocaine, which is a third-degree felony, and your offer to resolve the case is 6 months of probation, a drug class, and some community service with no conviction, you'll need to balance either taking that offer or going to trial and risk losing. If you win at trial, the whole case goes away. But if you lose, you'd be a convicted felon for the rest of your life, and the judge can sentence you to up to 5 years in prison. The decision to accept an offer or go to trial is entirely the client's decision, but an experienced attorney should be able to answer questions and provide information that may help you make the right decision for you. A good criminal defense attorney will usually get you the best result possible. What that result is depends on various factors, such as a person's criminal history, the nature of the crime and any minimum mandatory sanctions, the prosecutor assigned to your case, the facts of your case, the judge, the county, the police's investigation and strength of their work, and a number of other factors. So to summarize, the process works like this. There's an arrest or notice to appear. The individual bonds out of jail. They hire a solid defense attorney who waives their appearance at the arraignment and enters a plea of not guilty while demanding all of the discovery. Then, a series of pretrial conferences or docket soundings occur, during which time your lawyer will file various pretrial motions, examine the evidence, provide your own evidence, depose witnesses, file various pleadings, and ultimately litigate while negotiating with the state to achieve the best offer possible for you to resolve your situation. At a certain point, all of that pretrial work will be done and you'll have what should be the best offer to resolve your case. And you'll then have to decide if you want to take that offer or if trial is a viable and better option for you. Thank you for watching the video. I hope you found the information to be helpful. As always, nothing I said in this video or in any of my videos creates an attorney-client relationship between myself and whoever's on the other side of this video camera.